On February 9, 2026, something extraordinary happened inside the oldest judicial building in Scandinavia. The Supreme Court of Norway, its highest and most powerful legal body, wrapped up 3 days of oral arguments in a case that could reshape how the entire Western world thinks about religion, money, and human rights. On one side of the courtroom sat representatives of the Norwegian state, armed with internal documents, convention videos, and decades of testimony from people who said they lost everything, their parents, their children, their entire social world, because of one organization's rules. On the other side sat one of Norway's most prominent lawyers, Anders Christian Stray Risdal, defending the Watchtower Bible and Tract Society, the legal entity behind Jehovah's Witnesses worldwide. The stakes were not theological. Nobody was arguing about God or the Bible or who gets to go to paradise. The stakes were financial and legal. At issue was approximately 16 million Norwegian kroner per year, roughly $1.6 million in annual state subsidies, and the organization's official registration as a recognized religious community in Norway. But here's what makes this story different from every other legal battle the Watchtower has fought around the world. During those 3 days inside the Supreme Court, something happened that nobody expected. The Watchtower's own lawyer made a claim so bold, so easily disprovable, that the state didn't even need an expert witness to tear it apart. All they needed was a video from the Watchtower's own website. This is the story of the $1.5 million mistake. And before we dive in, I need you to understand something. This isn't just a Norwegian story. What happened in that courtroom has implications for every country where Jehovah's Witnesses operate, including the United States, where the Watchtower organization sits on over $1 billion in assets and enjoys full tax-exempt status. If Norway can pull the funding, the question becomes very simple: who's next? If you're watching this and you've been personally affected by shunning, whether you're an ex-Jehovah's Witness, a family member who's been cut off, or someone who's still inside and questioning, this video is for you. Hit subscribe right now because this channel is dedicated to investigative reporting on exactly these kinds of stories. And drop a comment below telling me where you're watching from. I want to know how far this story has reached. To understand what happened inside that courtroom, you need to understand how Norway's relationship with Jehovah's Witnesses unraveled over the course of more than 3 decades. Because this didn't start in 2026. It started with a handshake and a check. In 1985, Jehovah's Witnesses in Norway secured something incredibly valuable: official registration as a recognized religious community under Norwegian law. That registration came with tangible benefits. It meant the organization could perform legally recognized marriages. It meant they could access state subsidies, taxpayer money allocated to religious groups under Norway's principle of equal treatment. For context, Norway has a system rooted in its constitution, specifically Section 16, which states that all religious and philosophical communities must be supported on equal footing with the historically dominant Church of Norway. When the national church receives public funding, smaller religious groups get a proportional share. It's a fairness mechanism, and for 30 years, the Watchtower collected. By recent estimates, the annual subsidy for Jehovah's Witnesses, based on their approximately 12,600 registered members in Norway, came to roughly 16 million Norwegian kroner. That's about $1.5 to $1.6 million every single year. For 3 decades, nobody challenged this. The practice of disfellowshipping, the Watchtower's formal process for expelling members who commit what the organization considers serious sins, was reviewed by the Norwegian State Administrator in 1999, again in 2012, and once more in 2019. Each time, authorities concluded that the shunning practice did not provide a legal basis for refusing grants. The system worked. The checks kept coming. Then, on January 1, 2021, everything changed. Norway enacted a new Religious Communities Act, a comprehensive overhaul of the legal framework governing religious organizations. This new law didn't just set conditions for registration, it established explicit grounds for denying grants. The language was specific. If a religious community uses violence, coercion, threats, violates children's rights, violates prohibitions on discrimination, or in other ways seriously violates the rights and freedoms of others, that community may be denied state funding. The law also introduced a concept that would become the legal battle's central fault line: negative social control. The term refers to systematic pressures, often psychological rather than physical, that restrict a person's freedom to leave a group, make independent choices, or maintain relationships outside the group. Norway's authorities had been studying this concept for years, particularly as it related to immigrant communities and insular religious organizations. Now it had legal teeth. Almost immediately, the new law was put to the test. In 2021, 2 former Jehovah's Witnesses and a separate anonymous whistleblower sent letters to the state administrator detailing what they described as systemic shunning, family separation, and the psychological coercion of minors who had been baptized, sometimes as young as 12 or 13 years old. The letters described a world where leaving the faith meant losing everything: your parents, your siblings, your children, your entire social network. Not as a personal choice by individual members, but as an organizational directive enforced through congregation announcements and backed by the threat of further punishment for anyone who refused to comply. Valgerd Svarstad Haugland, the county governor of Oslo and Viken, reviewed the complaints. In January 2022, she made a decision that sent shockwaves through the Watchtower's global legal apparatus. She denied Jehovah's Witnesses their state subsidies for the year 2021. In her written assessment, she stated that the organization's exclusion practice, specifically its application to children under 18 and the consequences imposed on children who leave, violated children's rights under Norwegian law. She called it negative social control. The Watchtower didn't just lose money. By December 2022, after refusing to implement what authorities called corrective measures to their religious teachings and practices, the organization lost its registration entirely. For the first time in Norwegian history, a religious community had been stripped of its official status. They could no longer perform marriages. They could no longer collect state subsidies. And their 12,000 members in Norway suddenly belonged to a group that the state considered unworthy of public support. The Watchtower did what it always does. It sued. In December 2022, the organization filed 2 lawsuits, one challenging the denial of grants, another challenging the loss of registration. Those cases were eventually combined into a single legal battle. And so began a multi-year journey through Norway's court system that would test the boundaries of religious freedom, children's rights, and the power of the state over taxpayer money. The first trial took place in January 2024 at the Oslo District Court. For 2 weeks, the state and the Watchtower presented their cases. Former Jehovah's Witnesses testified about the lived reality of shunning. Parents describing the day they were told their child was disfellowshipped. Adult children explaining how a single congregation announcement erased a lifetime of family bonds. One witness, Jan Frode Nielsen, testified for the 3rd time in this saga. He described years of therapy needed to recover from what he called the institutionalized mentality imposed by the organization. When the Watchtower's lawyer, Reisdal, tried to attribute Jan's suffering to his divorce rather than his disfellowshipping, Jan pushed back firmly. Being disfellowshipped, not personal relationships, is the root cause of my suffering, he told the court. Another witness, Leander Jonah, was even more direct. Born into a deeply entrenched witness family with roots in the religion going back to the 1960s, Leander described reaching a breaking point in 2019 when he publicly spoke against the organization. His mother's response came by text message: "I cannot and will not have contact with an apostate." His entire family cut ties. When asked by the Norwegian newspaper Dagen about his experience, his words were stark. "I had the choice between suicide and leaving Jehovah's Witnesses." On March 4, 2024, the Oslo District Court ruled in favor of the state. Judge Ole Kristen Overberg concluded that, except in rare situations, Jehovah's Witnesses foster social isolation among disfellowshipped or disassociated members through their practice of mandated shunning. The court found that the conditions were met for denying both subsidies and registration. The Watchtower was ordered to pay the state's legal costs, over 1.1 million Norwegian kroner. But then came the twist. The Watchtower appealed to the Borgarting Court of Appeal, and in March 2025, a panel of 3 judges unanimously overturned the lower court's ruling. They reinstated the Watchtower's registration and declared the government's decisions unconstitutional. The Watchtower celebrated. On JW.org, the organization published a statement claiming they had been fully vindicated. Spokesperson Jørgen Petersen declared that the ruling confirmed the organization's right to practice its faith without state interference. For a moment, it looked like the Watchtower had won. The Court of Appeal awarded them 8.5 million kroner, roughly $800,000, in legal costs. Religious freedom advocates pointed to the ruling as proof that European courts would protect even unpopular groups. Massimo Introvigne, an Italian sociologist of religion, called the decision an important precedent that should warn other countries considering similar action. But the Norwegian state wasn't done. On April 24, 2025, the government filed its appeal to the Supreme Court. The case was admitted for hearing, and the stage was set for what would become the most significant religious freedom case in modern Norwegian history. February 5, 2026, Oslo, Norway. By 8:20 in the morning, the Supreme Court's Second Division courtroom was already packed. Journalists from across Scandinavia filled the press benches. Active Jehovah's Witnesses lined up outside, some traveling from across Norway. But so did former members, people who had lost families, careers, and identities because of the very practices at the center of this case. Only 2 or 3 former witnesses managed to get seats inside that first day. The case was live-streamed, an extraordinary step for the Norwegian Supreme Court, which typically operates behind closed doors. The advocacy site avoidjw.org hosted the stream on its homepage, and a dedicated Discord channel allowed thousands of former witnesses worldwide to follow the proceedings in real time. The state opened. Liv Inger Gjone Gabrielsen, the government's attorney who had been with this case from the beginning, laid out the legal framework with surgical precision. She told the court that equal footing between religious communities does not mean an unconditional obligation to fund them all. She listed the specific violations that could justify denying subsidies: negative social control against children, psychological violence, forced participation, and gender-based restrictions. And then she said something that cut directly to the heart of the matter. It is enough that the effect is directed at children. Gabrielsen walked the justices through the Watchtower's own published materials. She quoted from their literature, their congregation instructions, their training videos. She emphasized that this was not a case built on hearsay or the complaints of a few disgruntled former members. This is not just something expressed on paper, she told the court. This is something they do. It is a teaching that is followed and practiced. She pointed to the Court of Appeal's own findings, even in the ruling that favored the Watchtower, which acknowledged that the treatment of excluded members is essentially in line with what is described in the organization's own texts. She dismantled the Watchtower's comparisons to other religions, arguing that no other registered religious community in Norway applies such a systematic and formalized form of shunning. While some churches practice excommunication or social distancing in limited forms, only Jehovah's Witnesses implement what she called a comprehensive, organization-wide system of social death, complete with enforcement mechanisms and punishments for non-compliance. Then came February 6th, and Anders Risdal's turn. One of Norway's most respected and expensive lawyers, Risdal had won the appeal court battle. He was confident, articulate, and methodical. He framed the entire case as one of state overreach, a secular government attempting to dictate the internal beliefs and practices of a minority religion. He argued that denying subsidies amounted to a punitive measure against a group's theology, not its conduct. He cited Article 8 of the European Convention on Human Rights, which protects family and private life. He pointed to the 12,000 witnesses in Norway, a community he described as law-abiding, socially integrated, with children attending public schools and adults working ordinary jobs. And then he made the mistake. When addressing the state's documentation about Jehovah's Witnesses' internal practices, Risdal zeroed in on a specific word: shunning. He told the Supreme Court that the word should be understood as essentially neutral. He described it as merely an English verb meaning to avoid, nothing more, nothing less. He dismissed the emotional and psychological weight attached to the term, calling it exaggerated. It is very far from heavy material, he said. It does not indicate difficult family conflicts or difficult upbringings. But the state had come prepared. Before Risdal continued his arguments on the final day, Gabrielsen introduced additional documentation drawn directly from the Watchtower's own publications. Among them was evidence of a video that had been published on JW.org, the organization's official website, under the title, "Loyally Uphold Jehovah's Judgments, Shun Unrepentant Wrongdoers." The word shun was right there, in the title, produced and distributed by the organization itself. The video, originally created for the 2016 Remain Loyal to Jehovah convention, depicted a young witness named Sonia being disfellowshipped after entering a romantic relationship with a non-believer. The drama showed Sonia's parents forcing her out of the family home and cutting all contact, ignoring her phone calls for 15 years until she sought reinstatement. The video was not a critic's interpretation. It was the Watchtower's own instructional material, used in midweek meetings, featured at conventions, and presented as evidence of faithful obedience. The irony was devastating. Here was the organization's lawyer telling Norway's highest court that shunning was a critic's word, an exaggeration, a mischaracterization, while the organization itself had published a video using that exact word in its title, depicting exactly the kind of family destruction the state was describing. And there's an additional layer to this story that makes the Watchtower's position even more precarious. In 2024, after years of this video being cited in courts worldwide, including the original Oslo District Court trial in January of that year, the organization quietly removed the shunning video from jw.org. No announcement, no explanation. The link simply redirected to the homepage. Archival records from the Wayback Machine confirm the video was still accessible as late as October 2024 before being scrubbed. They also removed a 2023 convention video depicting a disfellowshipped mother being rejected by her own daughter's phone call, another piece of their own content that proved everything critics had been saying for decades. When the justices pressed Ristad on whether this case was about words or about the effects of the practices those words described, he pivoted repeatedly to selected witness testimony, carefully curated accounts of witness children attending school normally and maintaining contact with non-witness family members. But the judges weren't satisfied. They kept circling back to a fundamental question: what happens after baptism? What happens when a 12-year-old who was baptized reaches 16 and decides they no longer believe? What happens to that child's family? Ristad maintained that family bonds generally persist. The state maintained that the word generally was doing a lot of heavy lifting, and that the exceptions were devastating, systematic, and well documented. But here's where this story goes beyond a courtroom drama about one word, because the real battle in that Supreme Court wasn't just about whether Jehovah's Witnesses practice shunning. Everyone knows they do, including apparently the people who made the video. The real battle was about something much more dangerous for the Watchtower: the principle that a government can use financial leverage to force a religious organization to change its doctrine. During the hearing, Ristad drew the court's attention to the state's own decision documents. When Norway revoked the Watchtower's registration, the organization was given a deadline to rectify the situation that led to the denial of subsidies. If they wanted their funding and registration back, they would need to document corrective measures and submit them to the state administrator. And here's the critical detail: the decision specified that those corrective measures must concern the religious teachings of Jehovah's Witnesses, including practices related to social distancing. Read that again. The government of Norway was essentially telling a religious organization, change your teachings, or we keep your money. That's not just about subsidies. That's about whether a democratic state has the right to condition public funding on the content of a religion's beliefs. And that question, regardless of how you feel about Jehovah's Witnesses, should make everyone pay attention. Ristad framed this as a clear violation of religious autonomy under the European Convention on Human Rights. He argued that the state was using subsidies as a tool of coercion, a soft weapon that achieves what an outright ban could not. He pointed out that no other religious community in Norway had been subjected to this kind of scrutiny, despite other groups also practicing forms of excommunication, social exclusion, or moral discipline. The question is why Jehovah's Witnesses are being treated differently, he told the court, citing submissions from the Norwegian Helsinki Committee and academic institutions. The state's response was equally sharp. Gabrielsen argued that subsidies are not an entitlement, they're conditional. She distinguished between the right to practice a religion freely, which Norway fully protects, and the right to receive taxpayer money while doing so. No one is stopping Jehovah's Witnesses from meeting, worshiping, preaching, or following any of their beliefs. They can practice shunning until the end of time. But the state is not obligated to pay for it. This distinction between religious freedom and religious funding is the legal innovation at the heart of the Norway case. And it's why this story matters far beyond Scandinavia. Norway isn't banning Jehovah's Witnesses. It isn't criminalizing shunning. It isn't shutting down kingdom halls. It's simply saying, if your internal practices systematically harm people, especially children, you don't get to send the bill to taxpayers. The Watchtower knows exactly how dangerous this precedent is. Sweden has already taken similar action, paving the way for other governments to follow. If the Supreme Court rules against the Watchtower, there is no higher court in Norway to appeal to. The only remaining option would be the European Court of Human Rights in Strasbourg, a process that could take years and whose outcome is far from guaranteed, especially given the ECHR's existing jurisprudence on the limits of religious autonomy when it conflicts with individual rights. Now let's talk about the elephant in the room. The elephant that weighs approximately $1.5 billion. According to IRS filings, the Watchtower Bible and Tract Society of New York, the umbrella corporation for all U.S.-based Watchtower entities, reported assets of approximately $1.59 billion on its 2016 tax return. That includes hundreds of millions generated from the sale of prime real estate in Brooklyn, New York, including the sprawling Columbia Heights complex that sold for $340 million and the Dumbo facility that fetched $375 million. The organization lists its primary unrelated business activity on its IRS forms as investment activities. Let that sink in. While rank-and-file witnesses are encouraged to live simply and devote their lives to preaching, the organization at the top is managing a billion-dollar investment portfolio, and all of it is tax-exempt. In the United States, religious organizations enjoy extraordinary financial privileges under Section 501(c)(3) of the Internal Revenue Code. They don't just avoid paying income tax. They're also exempt from the standard reporting and transparency requirements that apply to other nonprofits. Churches and religious organizations are not required to file the annual Form 990 that secular charities must make public. This means the Watchtower's finances are, for the most part, a black box. The IRS has virtually no insight into how the money flows, where it goes, or how it's used, unless it initiates a formal audit, which requires authorization from a high-ranking Treasury official and is extraordinarily rare for religious groups. This is where Norway's case becomes a mirror held up to the American system. In Norway, the legal framework is straightforward. Public money comes with public accountability. If a group's practices violate human rights, particularly the rights of children, that group loses access to state funding. The group remains free to practice its religion. It just doesn't get taxpayer money. In the United States, the framework is almost the opposite. Religious groups receive enormous tax benefits with almost no accountability, and any attempt to condition those benefits on conduct, rather than belief, runs headfirst into the First Amendment. But the question Americans should be asking themselves is not whether the government has the legal tools to challenge the Watchtower's tax status. The question is whether the political will exists, and whether the precedent being set in Oslo might change the calculation. Consider what Norway has proven. It has proven that the Watchtower's own published materials instruct members to shun. The video with "shun" in the title makes that impossible to deny. It has proven that the practice affects children, minors who are baptized and later decide to face systematic social exclusion. It has proven that the practice is enforced, not just suggested, but backed by consequences for members who refuse to comply. And it has proven that the organization's own lawyer, when pressed in the highest court in the land, initially denied the very thing his clients publish on their website. If Norway, a country with a constitutional obligation to fund religious groups equally, can find a legal basis to say, "Not you, not anymore," what's stopping the United States? A petition on change.org calling for the IRS to revoke the Watchtower's 501(c)(3) status has been gathering signatures for years, citing the organization's handling of child sexual abuse, its cover-up of over 1,000 abuse cases exposed by the Australian Royal Commission, and its refusal to comply with court subpoenas. So far, the IRS hasn't acted. But every courtroom loss, every leaked document, and every country that pulls funding adds another data point to the case. On the final day of the hearing, February 9, 2026, Jan Frode Nielsen and activist Sorayas Nares traveled to Oslo for the closing arguments. They arrived early and secured seats front and center in the courtroom. Jan wore a shirt quoting musician Nick Cave, "This much I know to be true." Behind them, a herd of active Jehovah's Witnesses filed in. The state's closing was blunt. Gabrielson returned one final time to the organization's own doctrine. "This is the main rule," she said. "Avoid contact. Do not eat with such a person. Even a greeting can develop into more." When Risdal attempted to reframe shunning as mere social distancing, the state's response was a single sentence that may have decided the case. Changing the word does not change what is actually happening. The justices asked probing questions about proportionality, about whether the loss of registration and subsidies was too severe a consequence, about whether the state was effectively punishing belief rather than conduct. They questioned whether selective readings of religious texts could form a sufficient basis for such a serious intervention. And then, as the afternoon sun faded over Oslo, the oral arguments concluded. The justices retreated behind closed doors for their private conference. No rulings were announced, no outcomes revealed. The verdict is expected within weeks, likely by mid-March 2026. And whatever the Supreme Court decides, this case is not over. If the state wins, the Watchtower will almost certainly take the battle to the European Court of Human Rights in Strasbourg. If the Watchtower wins, Norway's government, and the thousands of former witnesses who have spent years providing testimony, reliving trauma, and fighting for recognition, will have to decide whether to push the issue at the European level from their side. But regardless of the legal outcome, something has already changed. Norway has forced a conversation that the Watchtower has spent decades trying to suppress. The word shun is in the court record. The video, even though the organization deleted it from their website, is in the evidence file. The testimony of Jan Nilsen, Leander Jonne, Rakel, Sorias, and dozens of others is a permanent part of the legal record of a Supreme Court hearing in a Western democracy. That can never be taken back. And to every person watching this who is inside the organization right now, every person who's been told that this case is persecution, that Norway is attacking Jehovah's people, that this is just another sign of the end times, I want you to consider something. The Norwegian government is not asking witnesses to stop believing in God. They're not asking witnesses to stop going to Kingdom Hall or studying the Bible or going door to door. They're asking one question: should taxpayers fund an organization that tells parents to stop speaking to their children? That's not persecution. That's accountability. If this story matters to you, and I think it does, or you wouldn't still be watching, then do 3 things right now. First, subscribe and hit the bell so you're the first to know when the verdict drops. Second, share this video. Share it with someone who's still inside. Share it with someone who left and thinks nobody cares. Share it with someone who's never heard of shunning and needs to know. Third, leave a comment. Tell me, should the United States follow Norway's lead? Should taxpayer funding for religious organizations come with conditions? I read every comment, and I want to hear your voice. The Watchtower has spent 140 years telling its members that the world is against them. But the truth is simpler and sadder than that. The world is finally starting to pay attention, and for the first time, it might actually cost them something.